Yes.
Thank you. If we could have DHSC 304421_141, please. We are picking up the chronology on the 30th of July 2003, a meeting with your Scottish counterparts. Is that right?
That's right.
And what I want to do, Mr. Gutowski, is flag some issues that we're going to return to later this morning and then focus on one point which I'll discuss now with you.
Okay.
But rather than having to come back to this document later in the morning, if we've noted it now, it will be helpful later. So we see on this page the heading Salient Issues, and there is a bullet point just below it saying devolution. Although the Scottish scheme is within devolved competence, the position with regards to Wales and Northern Ireland is less clear. If a UK-wide scheme is developed, its jurisdiction in the devolved provinces will need to be clarified and mechanisms of joint funding defined. Wales and Northern Ireland are not aware of developments so far, and a decision about the timing of their involvement is yet to be taken. Concerns were raised that there may be a legal obligation to share information. Can you explain for us at this point why Wales and Northern Ireland had not been made aware of developments so far, as at the 30th of July 2003?
As I understand it, and this was something that was not flagged up to me, but I was reminded of it by looking at the papers, and I'd forgotten about this, I must admit, is that there was a note somewhere in the papers that either you supplied or I was supplied from Secretary of State or his office saying that Wales and Northern Ireland were not to be involved in the initial discussions at this stage. It would be for England and Scotland to take things forward and then to bring Wales and Northern Ireland in at a later stage. And I think this was linked to the devolution issue. So at this stage, this was very early on in the deliberations and the considerations. It was just myself and officials in Scotland who were sitting down doing the preparatory work with a view to putting something, once we got agreement to do so, to the other two administrations.
And is that, we can find the note that you're referring to, I'm sure, over the lunch break, but from your best of your recollection, was that because there were still questions over the position in relation to devolution with Wales and Northern Ireland, whereas with Scotland you'd already had the law officer's advice and opinion?
I think it was more to do with the note from Secretary of State or from his office as to the involvement of Wales and Northern Ireland.
Perhaps that's a point, sir, I can pick up after lunch once we've identified the note that Mr. Gutowski is referring to.
I'm sure I'm not mistaken. I'm sure there is that note in there somewhere.
I also think you're right, Mr. Gutowski. I just can't instantly put my hands on the reference, but I'm sure those behind me will be looking for us straight away. If we turn to page 2 of this note of a meeting, we see the heading Proposed Parameters of the Scheme, and a decision's noted that the body would be arm's length from the government but administered by the Macfarlane Trust. And then in paragraph 3 we see this: an eligibility criterion for awards and the extent of supporting evidence submitted need to be determined. Where it exists, it is envisaged that claimants will generally be given the benefit of the doubt, e.g. because of lost, destroyed medical records, etc. And that's something we'll return to in a moment. It then goes on, but it is not expected that relatives, dependents and/or the estates of patients who have died will receive payments, even if they died between the announcement of the scheme and its launch. This approach would mark a change in precedent, as similar trusts do compensate the personal representative of eligible deceased patients. Then paragraph 4. The level of awards would be based on the Scottish model already speculated to the Scottish Parliament. Carries on with what those figures are. Paragraph 5, the initial £20,000 payments would not be made to patients who are co-infected with HIV and who have received awards from other government-sponsored schemes, such as the Macfarlane Trust. However, this group would be eligible to claim the £25,000 award should their condition progress to the trigger point. Eligible patients who cleared the disease spontaneously, approximately 20%, would receive no payments. Those points in relation to eligibility mirrored the Chisholm Scottish scheme. Is that right?
Correct.
Was there any discussion, or what discussion was there at this meeting, about whether or not it was right to follow what I'll call the Chisholm scheme?
I cannot remember. I think it was... the discussions were based on the fact that the parameters of the Chisholm scheme were there. We were given very little, if no notice, to set up a scheme. Therefore, it was viewed as being a sensible approach to use the Chisholm scheme parameters as a starting point, rather than go back to a blank piece of paper, given that we all knew that once the announcement was made, we would come under extreme pressure to get a scheme up and running as quickly as possible. One way of doing that would be to not, if you like, have to reinvent the wheel, if I can put it that crudely, that the Chisholm scheme was the wheel. Well, as I said, not starting from scratch, but using that as the basis of the way forward. It seemed at the time a sensible approach.
If one is using the Chisholm scheme as the starting point, was there any discussion then about the Chisholm scheme? Because from this memo, it might be suggested that it's simply been copied across and used.
I cannot remember if there was any discussions.
Another scheme that existed was the expert group report from Scotland, the Ross report.
Yep.
In your statement, it's paragraph 2.93, you've indicated that, perhaps we should put this up actually, Paul, WITN 5292016, page 46. Yes, as was set out we're picking up in the middle of 2.93, as was set out in the submission, the estimated costs of the Lord Ross earlier proposals were up to £60 million if applied to the UK for a scheme for which the Treasury was not prepared.
I think you said 60, it says 600.
600, yeah.
Sorry, sir, I missed. £600 million if applied to the UK for a scheme for which the Treasury was not prepared to provide additional funding. My understanding was that the Scottish Executive had ruled out that approach on affordability grounds. Likewise, Dr. Reid, as Secretary of State for Health, had made clear that we needed to find a scheme that was realistic in cost terms. Was that the primary reason why the Lord Ross proposals were put to one side and the Chisholm scheme was used?
I think it was, yes.
But you don't recall any discussions about what would be done with the Chisholm proposals beyond using them?
No. Can you put that back on the screen again? Sorry, I do apologise.
WITN 5292016.
If you look at, going back to the point we made earlier about the steer from Secretary of State, I think I cover that slightly in 2.94. The initial steer I'd been given was to work on proposals with the Scottish administration before inviting Wales and Northern Ireland to join in. I think that initial steer I'd been given was from either the Secretary of State himself or from his office.
And at the end of 2.94, you say that you needed to go for Council's advice on the issue of devolved matters for Wales.
Yeah, so that was the background to it.
Thank you very much. The fact of the ex gratia payments was announced by press release on the 29th of August 2003 and by written ministerial statement. And then if we go forwards to the 3rd of October 2003, it is DHSC 001 6672, please. We see it's a submission to the Secretary of State from you, dated, as I say, the 3rd of October. The purpose is to update you with progress on setting up the scheme and to seek your agreement on the various component parts. Then if we look under the heading Parameters of the scheme, we met with colleagues in the devolved administrations and agreed that the scheme should be identical to that proposed by Scotland, i.e. initial payment of £20,000 plus an additional £25,000 on reaching a medically defined trigger point. Just pausing there, at this stage, do you recall how much involvement your Welsh and Northern Irish counterparts had had?
No, I can... We'd obviously had discussions. Whether I don't believe, and I may be corrected by a document you may well show me, that there was minutes of a meeting. I don't think there was a meeting. It may well have been discussions we had over the phone.
How much involvement generally did the Welsh and Northern Irish counterparts have in this?
Without being too unkind, very little involvement at all from Northern Ireland. They tended to go along with whatever was being proposed by the other administrations. Wales were slightly more active, but not that much more active. Their involvement, they attended a few of the meetings in London, but their involvement came later on during the deliberations in the context of the guidance note and the application forms. But their involvement was minimal compared to the amount of time that ourselves and Scotland put into driving the scheme forward.
And do you remember any of the discussions that were had that resulted in the decision that the scheme would be identical to that proposed by Scotland? That shift from it being the starting point to it being identical?
No. I think that if I can put it crudely, that was a natural progression or a natural morphing into what was felt to be the correct way forward into what was actually going to be the case.
And I think I understood from your answers before the break that from your perspective, your team's perspective, it had always been the expectation that the Scottish scheme would be followed.
I think it was always the expectation, yes, given that the work, that initial work had already been done by Scotland.
If we carry on reading in paragraph 4, we see this: payments only to those alive when the scheme was announced on the 29th of August and who've not cleared this virus spontaneously. Within the basic criteria, there are a number of exceptions and variations, and these are listed at Annex A. These refer in the main to those patients who have received payment elsewhere or who have undergone some sort of medical treatment as a result of the infection. And if we go forwards to page 4, which is the annex, we see 8 points. Exceptions and variations to the Hepatitis C scheme. People who've cleared the virus spontaneously would not be eligible for any payment. People who have received payments linked to HIV infection from the Macfarlane Trust or the associated government scheme of payments shall not be eligible for the basic payment. They will receive the additional payment if they reach the medically defined trigger point. People who clear the virus under treatment shall only receive the basic payment. People who receive a liver transplant shall receive both the basic and the additional payment. People who have received compensation as a result of a successful legal action against the NHS or an out-of-court settlement in relation to a legal action shall have that compensation/settlement deducted from the total award made under this scheme. People who've received compensation as a result of a successful legal action against a product supplier shall have that compensation deducted from the total award made under this scheme. People who receive payments under this scheme shall undertake not to institute further legal proceedings against the NHS or ministers, and no payments shall be made to the relatives, dependents or estates of eligible claimants who were deceased at the time the scheme became operative. In terms of the exceptions and variations, it's right, isn't it, that there's no reference here to a cut-off date of treatment, that treatment had to have been received before September 1991.
That's correct.
And then if we can just turn back to page 3, please. We see the conclusion. I'd be grateful for your agreement on the criteria of the scheme, plus the exceptions and variations. So is it right that the Secretary of State was being asked through this submission to agree the exceptions and variations to eligibility for the scheme?
Yes.
On the basis of this memo?
Absolutely.
It might be suggested that there's very little information in this memo about the pros and cons of the different parts of the eligibility criteria. Would that be a fair suggestion?
Can you go back into the body of the submission for me, please?
If we start back at page 1, Paul, we see the note of parameters of the scheme that I read out. Then we have the heading medically defined trigger. And then if we turn to page 2, we have the headings of McFarlane Trust, other outstanding issues, patients' associations, and timing of the announcement.
Yeah, I take your point. I've got a feeling in the back of my mind, again, this is on the basis of a distant memory, and the papers may well or may not dispute what I'm about to say. The discussions with regards to those eligibility criteria may well have been based on discussions we also had with Melanie Johnson, who was the primary minister with responsibility. She had the portfolio for blood. But I cannot put my hand on my heart and say that I had or we had discussed it with her beforehand. But yes, on the face of it, these criteria are being put to the Secretary of State in very bold, very bold terms, if I can put it that way.
And not in a pejorative sense, but they're effectively a copy across from the Chisholm scheme, aren't they?
Yeah. I think it's useful to say at this juncture, if I may, that a lot of the discussions and, if you like, the day-to-day considerations with regards to the scheme and the parameter of the scheme were between us and Melanie Johnson as the responsible minister rather than the Secretary of State.
And we'll pick that up. We've got a memo
It's just that the nitty-gritty would have been, if you like, at that level, not at Secretary of State's level.
Just in terms of this document in October, the memo will come to in November, but in terms of October, it's fair, isn't it, that the exceptions and variations are drawn and copied across from Chisholm.
Yeah.
Just to be clear, that in your witness statement, you've said that the department hadn't received any expert advice on the appropriate level at which to set payments, had they? There'd been no other input from experts?
That we had actually commissioned ourselves?
Yes.
No, that's correct.
Nor in relation to the structuring of the scheme, so the fact of having a two-stage scheme?
Not at that point, no.
If we could then turn up DHSC 5328495, please. This is the memo from the 10th of November 2003, where we looked earlier at just one paragraph about the philosophy of the scheme.
Yeah.
I want to now look at some of the other details that we find in it.
Okay.
It's from you to PSPH. Following your meeting with Michael Connaughty, MP, Chairman of the All-Party Group, and the Haemophilia Society on the 29th of October, you asked for estimates of the cost of extending the scheme to those people who are co-infected with HIV, who cleared the hepatitis C virus, HCV, following treatment, and to dependents of those who have died prior to the announcement of the scheme. These groups were not included under the initial eligibility criteria agreed by Secretary of State in October, but not made public. And Mr Connaughty and the Haemophilia Society raised concerns that without their inclusion, they wouldn't be able to endorse the scheme. Recommendation. We suggest you ask the Secretary of State to agree to amend the draft eligibility criteria for the proposed hepatitis C scheme to make eligible for the initial £20,000 payment those people with HIV co-infection, and make eligible for the initial £20,000 payment those people who have cleared HCV following successful drug therapy. And then under background, we've taken this opportunity to revise the original cost estimates for this scheme. These were made on the basis that up to 8,500 potential claimants would be eligible for payments under the initial draft eligibility criteria. This suggested that a budget of between £162.5 million and £212.5 million would be required, depending on the number of eligible claimants making applications. I think we've got the wrong page. There should be a... Thank you. Claimants making applications, 162.5 equals 50% take-up, £212.5 million equals 100% take-up. Updated estimates and a more comprehensive analysis of these figures appears to show them to be an overestimation due to double counting and inclusion of some non-eligible groups. Our further analysis appears to show that the original calculations included those patients that have cleared the virus with treatment and those who are co-infected with HIV. These are two of the key concerns of both the Haemophilia Society and the All-Party Group. Subject to more detailed calculations being carried out, it would appear that we could offer to include these within the proposed scheme without incurring any additional costs. So just pausing there to make sure that it's clear, those who were co-infected and those who cleared the virus after treatment had in fact already been included in the budgeted figures. Is that right?
Yeah, it had been double counted, but we hadn't realised at the time.
And so we then see in paragraph 10 the outstanding question of dependents, the cost of extending the scheme to dependents, more than £154 million, would at least double the cost of the scheme and remains unaffordable within the existing budgets of all the 4 health departments. Do you know where that figure of over £154 million comes from?
No, I mean, this is going to sound very silly, but it was obviously based on a calculation done somewhere within Health Protection Division and the Department's Finance Division. But I cannot tell you the basis upon which that 154 million was calculated, but it clearly was, because it's a very precise figure.
Do you have any knowledge or recollection of whether that assumed that both a stage 1 and a stage 2 payment would be made to dependents of those who had died?
That is a level of detail I cannot make comment on, sorry.
And do you have any recollection of whether it was calculated on the basis of a payment per person who had died or a payment per dependent?
Again, I can't answer that, sorry.
I'm sure, sir, that your maths is better than mine, but I think that if only stage 1 were paid, it would be the equivalent of 7,700 payments being made. And if a stage 1 and 2 payment were being made, that would be the equivalent of 3,422 payments.
Yes, I think your maths is right.
I'm glad. On reflection, Mr. Gutowski, do those figures of how many payments were thought would be necessary, do they strike you as somewhat too high?
I honestly can't. It would be wrong of me to try and make a comment on that, because I've got no recollection at all on how the basis upon which that 154 was calculated. But it clearly was, and at the time was a figure that was accepted. But I can't help you further. I'm sorry.
Do you remember any discussion at all about that figure?
I can remember no discussions at all.
If we then carry on this page, on the next page, paragraph 11. The Haemophilia Society and the all-party group have 4 outstanding concerns regarding the proposals and draft eligibility criteria for the scheme. The proposed payments are lower than those recommended by the Scottish Executive Expert Group and their own expert working group recommendations. No payments are being made to dependents. People who have cleared HCV following drug therapy are not eligible. People who are co-infected with HIV will not be eligible for the initial £20,000 payment. With the figures above in mind, we are therefore in a position to negotiate with the Society and the all-party group and would be able to accommodate the last 2 demands at no extra cost. However, agreeing to the first 2 demands would embarrass the Scottish Executive, who have already announced the size of their awards and that they will not make payments to dependents. Just pausing there, can you expand for us on what the concern was here?
No, I can't, sorry.
And do you recall any discussion about this and the weight that was placed on this issue?
I can't recall any discussions on it. Sorry.
We carry on. Be unaffordable within the existing 4 health budgets. Require Secretary of State's agreement to amend the proposals and draft eligibility criteria. Advantages and disadvantages of extending the scheme to include co-infectants and successfully treated patients. Advantages: DH is able to include these groups at no extra cost to the original estimates. DH would be seen to be listening to the arguments put forward by the Haemophilia Society and the all-party group and the needs of the people it represents. Just again, pausing there, when there were discussions with the Haemophilia Society and the all-party group, was it said to them, actually, you're within the original envelope of the budget requirements anyway, so this isn't an issue, or was it presented as a negotiation?
I don't think it was presented as a negotiation. I think it was presented to them as the basic criteria. And it would then, once we had, if you like, amended the criteria, we would put it to them on the basis that the criteria had been amended. But I don't think at that time it would have been put to them that it was as a result of double counting or whatever.
Bullet point 3, DH would expect the all-party group to be more supportive of the scheme than they'd previously indicated. And then this, DH agreement would undermine and marginalise the Haemophilia Society's lobbying position. Can you help us with why that was seen as an advantage?
I can't. When I read that, I was actually surprised it was in there. I don't understand it. But having said that, at the time, when I wrote it, there must have been something in my mind that made me put that down in a submission to Minister. But for the life of me, since the documents were presented to me, I can't remember what the reason was behind me putting that as a 4th bullet point.
And then the final bullet point, the Macfarlane Trust, whose only non-negotiable demand is that co-infectants are included, would be satisfied and have today confirmed that they would be prepared to administer the proposed scheme if this condition was met.
Yeah.
And then we turn the page. We've looked at paragraph 14, but I want to pick up paragraph 15, conclusion. there remains little scope for satisfying the Haemophilia Society's demands in full, their request that DH considers increasing the size of awards and that dependents be eligible for financial assistance are unsustainable on the grounds of affordability. However, extending the eligibility criteria to include co-infectants and successfully treated patients would not require additional funding. So again, perhaps a very obvious question, Mr. Gutowski, is it right that fundamentally it came down to the money?
Absolutely.
For the transcript, we don't need to go to it. The figures were then put to the Secretary of State by Melanie Johnson on the 3rd of December 2003, and the reference for that is WITN 5292020.
I mean, going back to your previous point about the funding, it's got to be remembered the context in which all of this was being negotiated and drawn up. I mean, there were very, very strict constraints on the Department of Health budget as a whole, and the fact that the Treasury had not provided any additional funding for this. So to pay for the scheme, no matter what the parameters were, resulted in quite substantial, quite substantial cuts being made across the board, across the whole of other DH budgets, which were regarded by the recipients of those budgets as being as important as this particular issue. So one needs to bear in mind that it was a very difficult time with regards to funding. It was also a very difficult time in regards to staffing cuts within the Department of Health, which were quite stringent at the time in order to meet the budget constraints we were all working under.
You picked this up in your witness statement as well, Mr. Gutowski, that
Okay.
There had been particular criticism that the scheme didn't include payments to relatives, dependents and the estates. And you've said that the Scottish scheme had been designed with this exclusion, but that you'd flagged it up as a problem. And then you said the scheme was designed to help those who were living and suffering as a result of being infected with hepatitis C, and you say affordability was a very major issue.
Yeah, absolutely it was.
I just want to explore that affordability question a little bit more with you, because you indicate that, as we've seen in other documents, that the Treasury had made it clear that money for the scheme had to be found from existing health budgets. Can you just help us with what the process was in order to try and obtain more money from the Treasury?
I think it was made very clear at the outset that there wouldn't be any more money. And as to how much additional pressure was put on them by Department of Health Finance branches and officers, I don't know. I'm assuming that they did try and fight our corner, but clearly not successfully. I think that minute I alluded to earlier from Paul Boateng was actually quite rigid.
We saw that very early memo of the meeting, or the note of the meeting between John Reid and the Chief Secretary of the Treasury, which said there was no money. Can we just step back to a level of generality for a moment? No, my fault, the question wasn't clear. Can we step back for a moment to just a level of generality? If the Department of Health needed more money from the Treasury, what was the process to try and obtain that?
I'm guessing because I've never worked in finance, but I'm assuming there would be a line of communication obviously at a senior level or ministerial level to put in supplementary bids or whatever to the Treasury for more funding for specific projects or across the board, and then that would be dealt with by whoever in the Treasury had responsibility.
So in terms of lines of communication, you would go to the department's finance team for them then to ask the Treasury or for the Minister or the Secretary of State to deal with it at a higher level?
That would be my understanding of what would happen. And your next question is, did I? I can't answer that because I can't remember whether I made a formal request for the finance branches to go and request more money for this scheme.
And did you make John Reid aware of the limitations that would be caused to the scheme because of the Treasury's stance?
Specifically, did I raise that specific point with him? Or did I...
Or with Melanie Johnson?
Or did I accept that they will understand it anyway? I can't answer that again. I don't recall in any of the documents that have been presented to me of seeing that I'd actually gone to Minister and said, you do realise that Paul Boateng's refusal to give us more money is going to affect the scheme. I don't recall seeing that anywhere.
I'm sure if there is something, I'll be corrected from behind me.
But I could well have, because I had many, many meetings with Melanie Johnson on all the issues within my portfolio. This would have been an issue that we would have discussed. But again, I've got no official record of that or recollection.
And would it be fair that, in a sense, you might have flagged it upwards to somebody, but it wouldn't have been for you to go to Treasury and say, we need more money? That would have been somebody else.
No, it would have been way above my pay grade.
Before I move on to another of the eligibility criteria for the scheme, I want to explore two other matters that I've been asked by call participants to raise with you. When the details of the scheme were announced in January 2004, it was via a written ministerial statement as well as a press release. Is that your recollection?
That's my recollection.
Why was it done as a written statement rather than as an oral matter in the House?
Because that was the procedures at the time, that if a minister or the department had an important announcement to make, they would do it via a written statement to the House, rather than ask a tame MP, if I can put it that way. I mean, you know what I mean. To put down an oral question to which they could answer. And also it gave more gravitas to the announcement if it came via a ministerial statement, because that ministerial statement, as a matter of procedure, would be circulated to the opposition health spokesman beforehand, so they can prepare a suitable response.
I'm asked to ask you whether there was any awareness or discussion about this, that by being a written ministerial statement, it would mean there was no scope for MPs to ask questions or debate the issues that were being announced.
No, if you put a written statement to the House, the opposition spokesman then has the opportunity to make comment on that statement from his perspective and ask questions. And then if there was then a need for follow-up debate or questions, and that will be down to MPs to instigate a debate on that particular subject, or to ask written questions or put down oral questions to the minister. And as you've no doubt picked up from my statement, we were subject to an incredible amount of parliamentary questions and correspondence surrounding this scheme.
So just to be clear, that by putting it out as a written ministerial statement, your evidence is that that wouldn't prevent a debate later or questions later?
Oh, absolutely not, no. I think putting out a written statement, I mean, even now, I mean, I don't know, I mean, I've been retired a while now, so putting out a written statement in the House is a very strong indicator from a minister that he wishes this to be taken with a high level of importance.
The second point relates to the decision that the Macfarlane Trust would run the Skipton Fund. That was a decision that you were very positive about.
Absolutely.
And in your statement, you say that by 2003, the Macfarlane Trust had well over a decade's experience in helping haemophiliacs who'd contracted HIV through infected blood or blood products, and this meant that those involved with it, including Mr. Stevens, had a wealth of knowledge which was invaluable when setting up the Skipton Fund and ensuring it operated well.
Yep.
2.9 of your second statement. What were you particularly thinking of when you referred to his wealth of knowledge?
Exactly that. He knew his community, if I could put it that way, and he knew the blood sector and the concerns and the problems there were. I think it was, if I can put it this way, and I know that some people disagree with me. At the time, it was almost a no-brainer to go down this road in the sense of getting a scheme up and running quickly rather than trying to set up a trust or a fund or a company from scratch to administer the scheme. It felt to us that this was a way of moving things along quickly, given the perception, political perception and public perception, that once a scheme had been announced, we as civil servants were going to go to a drawer somewhere, take out a scheme, put it on the table, press a button and say, right, there it is. Let's start making payments now. It doesn't work that way in reality. You've got to set up a scheme from scratch, and there's a lot of work involved in that, as I think my statement alluded to. And one of those would be to set up the mechanism to do that. And to use the Macfarlane Trust, seemed to us, would be a sensible use of their expertise and resources.
If we can then move on to the question of the cut-off date, the September 1991 cut-off date. We've seen the earlier memo we looked at earlier today that in the very initial documents about eligibility, there was no reference to a cut-off date before which people had to have had received the blood or blood products.
Yep.
By the time of the press announcement in January 2004, it is in the notes. But I just want to explore that question of the cut-off date. First of all, before we look at a document, there wasn't a cut-off date for the Macfarlane Trust, was there?
Not that I'm aware of.
So why was it felt that hepatitis C should be treated differently to HIV?
I can't answer that, I'm sorry. I've got no recollection of why that decision was made. I've thought about it since the papers were presented to me, and I just can't get my brain around why there was.
Could we then turn to DHSC 304520 _059, please? And if we could turn to page 3. This is an email you sent to Peter Stevens in October 2004 in response to various notes on queries. And I just want to pick up the 5th paragraph down, where you say, as to the patient who received contaminated blood on the 17th of September, we believe he should be paid, and suggest you introduce a 35-day rule after the 1st of September, which is the normal shelf life for blood. Can you explain how you came to suggest the 35-day rule?
No, I'm afraid I can't. I must have been on the basis of advice. I mean, I wouldn't have just plucked it out of the air put it into a letter. It's something so specific and so important. I cannot explain why I came to that particular or made reference to that 35-day rule.
It appears that what you're dealing with here is whole blood. Do you recall any discussion about the shelf life, if we can call it that, of other blood components, for example, FFP, fresh frozen plasma?
I can't recall any such discussion, sorry.
But would it be fair that from this email, your understanding was that from October 2004, you expected the Skipton Fund to pay, to accept as eligible somebody under the scheme if they received blood or other components 35 days after the 1st of September. So the cut-off then moves by 35 days.
That's what I'm saying there, yes.
Did you at any point discuss with the Skipton Fund whether they were in fact then implementing that rule?
I would have communicated to them that they should implement that rule, yes.
This is the email to Peter Stevens. Is this you? Is that communication?
Yes, because I say, and I suggest you introduce a 35-day rule, yes. That would have been my communication to him.
Thereafter, did you have any discussions with anyone about it?
Not that I can remember.
I want to then turn to the question of natural clearers, as it's been phrased in the papers. Initially, as we've seen, natural clearers were excluded from the scheme, but subsequently you became aware that some people didn't clear the virus until they'd already reached the chronic hepatitis stage, in light of which you recommended a change to the eligibility criteria and the 6-month time frame. Could we go to DHSC 5346629, please? This is an email from Peter Stevens to you and Bob Stock in September 2004. And if we turn the page, we see a bullet point that starts the Part 2A questions. Thank you, Paul. The Part 2A questions continue to cause great difficulty, and I trust that you're hard at work consulting on these. Some further illustrations of the problems. Bob already has some stuff from me on this. A clinician said that a patient was PCR positive, but added that he hadn't been tested since 1998. We took this as a qualifying. The 2A questions were answered yes, no, no, and no, but the clinician went on to say that the applicant had had persistently abnormal ALT tests. After a similar set of answers, the clinician said that a liver biopsy on a haemophiliac showed him to have cirrhosis. In another similar case, the evidence of cirrhosis comes from CT scanning and ultrasound. In yet another case, the second question, PCR negative, was unanswered, but the clinician said chronic hep C had been diagnosed. Finally, we have a case from Brian Colvin at the Royal London, who has signed off lots of applications, but on this one cannot complete the form. From a long and detailed letter, the position appears to be the applicant is a long-term hep B carrier with partial immunity to that virus. He's also HCV antibody positive, and in 1995 and April 2003 had positive HCV PCR test, but in 1991 had a negative one, which Colvin believes to be a false result. HIV treatment caused a flare-up in his hep B infection, which then resolved spontaneously. As his HIV treatment led to an improved immune system, his HCV PCR test became negative spontaneously in October 2003 and remains so. Colvin concludes that the applicant clearly is and was chronically infected with Hep C and nearly died of liver disease and should qualify for the second stage payment, but appears to be of doubtful eligibility for the first stage payment. This has to be nonsense. These all show that the 2A questions are not leading us or the clinicians to clear conclusions. Furthermore, one of the London-based directors is Elizabeth Boyd, who's a DOH-appointed MFT trustee who works at the Royal Free. Her understanding, based on Christine Lee's knowledge of Hep C, is that nobody who is PCR negative without receiving interferon-based treatment would have experienced any of the symptoms mentioned in 2A4. She is therefore not passing any natural clearers, which forces the rest of us to follow suit. But until she made this plain, I'd already passed quite a lot of such cases. So we have inconsistency of treatment on this point within Skipton, matching that from the clinicians, about which I've already told Bob. My belief is that this is not a major problem in terms of numbers and can be resolved by taking a different view of this point that was much debated earlier this year. In other words, I think we should abandon the distinction of viral clearance between those whose clearance followed treatment, the majority of clearers, and those who did so naturally. I do not believe that the cost to the scheme would be significant. But we do need greater clarification on this point at the very least, and should not be distinguishing between those whose clinicians only tick the boxes and those who add sufficient arguments as to indicate that being PCR negative without taking interferon and without clear evidence from the acute stage is not, in fact, a sound or fair reason for withholding payment. I could suggest appeals panel, but think that we actually need a redefinition of eligibility. The panel would be similarly stymied by the rules of the scheme, which are themselves the root of the problem, since we did not find a set of questions in Part 2A which sufficiently defined how to discriminate against this small group of people. That was the email from Peter Stevens. We then pick up on the 21st of September 2004. You attended a Skipton Fund teleconference, and I'd like to look at those minutes and then ask you some questions.
Yep.
DHSC 304510, please. That's not what I intended. DHSC 304510_080. Thank you. We have here minutes of a meeting. It's flagged as draft at the top, so please say if you think they're not accurate or not final. Dated the 29th of September, we can see that Christine Lee attended, Bob Stock, Aileen Keel and others, and yourself. And if we go down to the heading Natural Clearers, 2.1, Prof Lee was invited to speak to the group regarding her concerns about inconsistency in the reviewing of natural clearers, NCs, by clinicians. Clear instructions are required for clinicians in order to eliminate this disparity. Just pausing there, given that you were aware of differing medical opinions, why was Professor Lee invited to speak at this teleconference?
I don't know. I cannot answer that.
Was there any consideration given of inviting someone who held the opposite view of Christine Lee?
I can't answer that either.
The minutes then record 2.2. The fund was set up by ministers for those who've endured physiological suffering, stroke damage by contracting hepatitis C, and not for the worried well or asymptomatic. Most NCs clear very soon after infection, patients, i.e. during acute phase, and never become symptomatic. Hence, according to the terms of the fund, they should not receive payment. 2.3, the only accurate methodology to determine at which stage, i.e. acute or chronic, that patients cleared is to backtrack to the time of infection by PCR testing samples. However, most hospitals do not hold samples for patients back to 1977. i.e. average time patients contracted hepatitis C, and so this will not be possible. We carry on to 2.5. It's unlikely that the doctors completing patients' forms were treating them at the time, and so will be unlikely to be capable of accurately reporting whether they were asymptomatic during the relevant period, and asking the patient is not viable given the £20,000 at stake. A number of cases supported by clinicians may therefore be based on sympathy rather than medical evidence. Blood transfusion patients are unable to be traced, but it's probable that a number may come forward in the future. Testing is likely to show patients to be PCR negative, even if antibody positive, and probability suggests that they will have cleared during acute phase while asymptomatic. In such a case, patients would not be eligible. Conclusions: original criteria defined by ministers must be adhered to, i.e. physiological damage. Acute stage clearers are not eligible. Chronic stage clearers are eligible. PCR positive samples required for eligibility. Skipton Fund to be advised accordingly. On the face of this document, it appears that Christine Lee's view has been followed during this telephone conference. Would that be fair?
It appears that to be the case, yes.
Do you recall any discussion about that view?
No.
And then could we turn on to DHSC 306798_072, please. It's a memo from you to comms, presumably communications department.
Yeah. Press office.
Press office, thank you. It's quite a long memo, but I am going to read it out and then ask you some questions at the end. When the Hepatitis C payment scheme was introduced last year, the 4 health ministers in announcing the scheme detailed the eligibility criteria for payment. One of the criteria of the scheme has been that those patients who were infected with hepatitis C by infected NHS blood, but who cleared the disease spontaneously in the acute phase, usually the first 6 months of infection, were not eligible for payment. Statistics indicate that 20% of all people infected with hepatitis C clear the virus in the acute phase without long-term physical damage. The policy adopted by all 4 health administrations from the outset has been that no account would be taken of any pain, discomfort, loss of earnings, etc. incurred in the past, or of psychological damage or social disadvantage continuing after they cleared the virus. More recently, it has transpired that a very small number of people clear the virus after the infection, continuing beyond the 6-month period, i.e. in the chronic phase. It was decided to include these people within the scope of the scheme. People who clear the virus in the chronic phase as the result of treatment were already included, following advice from DWP. All the above decisions were made following submissions to the 4 health ministers and the criteria made public. Even so, a number of claimants, about 90, have made claims, knowingly or mistakenly, outside the stated eligibility criteria of the scheme. Unknown to us, the Skipton Fund, who administer the scheme on our behalf, have held on to these claim forms rather than reject them on receipt. They asked for further clarification of the situation and have now been instructed to send out the rejection letters which are going out today. We've asked them to include the following explanatory paragraph in the letter. Patients would only be eligible for the first payment if 1. There was evidence that they had developed chronic hepatitis C infection, but this had resolved spontaneously, thought to be a reasonably rare situation, or 2. Had developed chronic hepatitis C infection, but subsequently cleared the virus as a result of treatment. Patients who had or were thought to have eliminated the virus in the acute stage, when they would most likely have been asymptomatic, or where any symptoms that did occur would have been short-lived because of the transient nature of the infection, would not be eligible for this payment. It should be assumed that the virus has been cleared in the acute phase, unless robust medical evidence is cited that proves on the balance of probabilities that the patient experienced chronic infection, i.e. infection that extended after the first 6 months of illness. just pausing there, in relation to that phrase, robust medical evidence, what was anticipated would be required in that regard?
I can't answer that question. I don't know. I would have clearly taken advice from medical experts within the department and outside, but as to what those 3 words cover, I can't say to you now that robust medical evidence is A, B, C, D, and E. I don't know.
Earlier today, we looked at meeting minutes from July 2003 of that meeting held between you and your Scottish counterparts.
Yeah.
And we noted then, and I'm very happy to take you back to it if you'd like, that generally it had been agreed that claimants would generally be given the benefit of the doubt in relation to evidence because of the difficulty with lost or destroyed medical records.
Yeah.
How does that fit with this document in November 2004 requiring robust medical evidence?
I can't answer that. I don't know.
Do you recall any discussion that there would be a change of approach?
No.
And at the time, did you consider that it was a change of approach? I probably should have asked those the opposite way round.
I clearly, on the basis of this, didn't think it was a change of approach.
With the benefit of hindsight, would you accept that requiring robust medical evidence is a step away from giving claimants the benefit of the doubt?
I think you need to look at it in the context of the actual what the evidence was needed for. So I wouldn't like to speculate that it was, even with hindsight, a change of direction.
You said a moment ago that you think that you must have had some medical expert input.
Input, yeah.
Do you recall who that was that gave you that?
My senior medical officer within the department who provided me with the majority of my advice on this was Hugh Nicholas. He was a senior medical officer who was part of Health Protection Division. And my guess is that Bob Stock in Scotland would have gone to his medical advisors, maybe Aileen Keel, who was a deputy chief medical officer at the time.
Then let's pick that up in relation to Hugh Nicholas. Could we, sorry, just before we go that, before we look at the Hugh Nicholas Aileen Keel question, do you recall it going outside of the Department of Health at all?
I don't recall whether I did or I didn't.
Then let's just have a brief look at this. DHSC 304520_057. If we pick it up on page 3, please. It's an email chain starting with an... It starts with an email from Zabida Sedat to Bob Stock and to you. And the email we're picking up here is Bob Stock's response. It's dated the 15th of October. And we can see in the second paragraph of the email the drafting of this question, this paragraph that would go into the letters. And we see the phrasing, unless robust medical evidence is cited. Yeah. We can see there that Bob says, I've discussed this with Eileen and offer the following amendments.
Okay.
That's something we can pick up away from today. But if we then go to the page before, we see Zabida forwarding it on to Hugh Nicholas for his views. And if we go back to page 1, we pick up Hugh Nicholas's email. Bob has changed one sentence in my draft and added another final one. I'm content with the additional sentence, but wish to question the amendment to my draft. It concerns the likelihood of patients being symptomatic or asymptomatic in the acute phase of the illness. Bob has replaced my when they would most likely have been asymptomatic with when they would have been highly unlikely to be symptomatic. This may only seem a small point, but there does seem to be a change in emphasis here. Whilst I agree that those who experienced a flu-like illnesses would not have realised that this was due to hepatitis C at the time, there will be a few who develop jaundice. Some authorities have stated this may be up to 20% of cases, though I suspect it may be much lower, 5 to 10%. Nevertheless, jaundice can occur, and my concern is that we may be seen as overemphasising the asymptomatic nature of acute hepatitis C infection. Interested in others' comments and whether we need to take the views of clinicians on this. And then if we go to page 1, we have a response from Mike Simmons. You're not copied in this part of the email, but Mike Simmons indicates I'm not sufficiently knowledgeable to give a view on the changed wording you discussed to give an informed opinion. If others are also unhappy, then your suggestion seems the sensible option. If in doubt, seek a hepatological opinion. My question for you, Mr. Gutowski, is whether a hepatological opinion was sought or whether there was simple reliance on Hugh Nicholas and Eileen Keel.
Whether Hugh sought hepatological opinion, I don't know. I have no recollection of doing so.
And just to close off the final part of the natural clearers issue, is it right that William Conan was not briefed on this issue when he took over from you?
Specifically on natural clearers?
Yes, this was a live point.
I can't remember the handover we had, so I can't say whether I briefed him on it or not. But given it's such a, I won't say small point, but given it's a very specific point in this this whole area, I doubt I would have specifically alerted him to problems on natural clearers. I can't remember what we discussed in the handover.
If we pick up an email from Peter Stevens to Frank Hill, HCDO 402442_051. It was certainly Peter Stevens' impression that he hadn't been briefed. We see this. Martin Harvey, CEO of McFarlane Trust, and I had a long meeting yesterday with William Conan, the new official at the DOH who has succeeded Richard Gutowski. In the course of some 2.5 hours on a range of McFarlane and Skipton issues, we spent quite a while on the issue of the exclusion of natural clearers from the Hep C scheme. Conan had clearly not been briefed on this, so while he knew nothing about it, at the end of a long discussion he did at least venture the opinion that there might be something there to consider. And then at the bottom of the email, incidentally, as you might be aware, there is a new official in Scotland as well, in succession to Bob Stock, who was the only one of the quartet last year who appeared to have any understanding of the issues anyway. So an approach by UK HCDO has even less entrenched opposition to overcome than if Gutowski was the only departure from the scene. Can you explain why Mr. Stevens might have had the impression that there was entrenched opposition in relation to this issue?
No. I mean, he wouldn't have got it from me.
He wouldn't have got what from?
He wouldn't have got an impression from me that there was entrenched opposition.
Another issue that Mr. Stevens raised with you very early on in November 2003.
I mean, I have to say this is the first time I've seen this.
Yes, you're not copied in the email.
No, but as I'm saying, it wasn't even in the bundle of papers. I have no recollection of this having been sent to me.
I can go back and check that out. I think.
Well, it may be. There was over 5,000. So, but I don't. It doesn't jump out at me as something I've seen even recently.
I mean, it does rather look as though Peter Stevens thought, because he says, in effect, that you were somebody who had entrenched opposition to what he was suggesting.
Yeah.
Did you? Do you accept that or not?
No, I don't.
An entirely separate issue in relation to eligibility. Another issue Mr Stevens raised with you very early on in November 2003 was about including those who'd contracted hepatitis B only. We don't need to go to it, but for the transcript, the reference is SCGV 40256_051. Why was that not pursued, including those who had contracted hepatitis B?
I don't know. I thought about this when I got the papers, but hepatitis B was not something that jumped out at me that we'd given consideration to. I'm trying to, even now, I can't recall much discussion around the area of Hep B.
And then the final point in relation to the Skipton Fund. Can you help us with why the appeal process was not set up immediately that the fund went live?
We talked about it, as you've seen from the papers, and we discussed it, and we discussed the criteria of setting up an appeals system and who should sit on the appeals panel. There was some initial discussion as to whether the people that sat on the appeals panel should be public appointed under the Nolan principles. And that delayed the process. And I have to say, and I put my hands up now and apologise and accept the fact that we should have processed or progressed the setting up an appeal panel quicker, in a more timely manner. But given the resources that we had, because by then my staff had been reduced down to one, so it was just me and one member of staff taking forward the whole of the blood portfolio, and there were other issues that were up and running. The fact that the Skipton Fund was actually progressing payments, that work on the appeals panel did not progress as quickly as it should have done, and I put my hands up and I apologise for that and take full responsibility for it not happening quicker.
We've got a memo from William Conan, obviously him having taken over. It's November 2005. I want to take you to it,
okay,
to see whether the issues that he raises are the same issues that you were facing in relation to the appeal panel.
Okay.
DHSC 0041162_058, please. We see it's a follow-up briefing for the APPG meeting in the 10th of November. Background to establishing the Skipton Fund Appeals Panel, timetable. It was announced by press notice on the 3rd of June 2004 that applicants would have the right of appeal. A consultation exercise was undertaken with key stakeholders on the composition of the panel, including with the DAs. This exercise was not completed until spring 2005. The initial focus was on making payments and finalising the agency agreement before putting the appeals procedures in place. Very limited departmental resources have delayed completion of the appeals process. Then appointments. It's still not been confirmed that the NHS Appointments Commission will be able to take on this work. The main question is whether they can take on the Skipton Fund as decisions made by the trustees and not the Secretary of State for Health. If the Appointments Commission cannot handle the appointments, then we'll have to identify a suitable external agency. Whoever handles the appointments, it's likely to be some months before the panel members are appointed and in post. The job descriptions will have to be agreed, adverts placed, and people interviewed and appointed, which we anticipate could take several months. Again, limited staff resources have hindered the development of the appeals procedures. And that's the point about the appeals. So is that reflective of the issues
Yes,
that you also face?
Absolutely, yeah.
So I'm about to move on to a new topic, and I note the time, so I wonder if it's a good time to take our lunch break.
Yes. Well, we'll take a break until 2 o'clock. 2 o'clock.